This would be case D331190, Velasco. Plaintiff is present pro se. Counsel prints the record.
Mandy McKellar, Your Honor, on behalf of Antonio Velasco, bar number 10437. He's present in court today.
Okay. We were last here on December 7th, 2015, on the defendant's motion to modify child custody. It was established at that time. I don't see a scope yet. I may consider actually running one today since I now have the child interview. Have you received the child interview?
Yes, I have.
Right.
I haven't received it. I was able to.
Well, you were able to review it?
Yes, I was.
Can we agree that it's probably not very positive toward the children and your significant other?
I believe that there has been some significant coaching in that interview.
Okay.
Well, I was going to argue that it seems like Mom was doing some coaching when the child mentioned a slight shove. I don't think it's appropriate for any child to witness domestic violence, but it felt like when I read that it was a little coached to state that it was a small shove.
May I say something about that, please?
Okay.
After reading that child interview, I had talked to my daughter and I had asked her exactly what she had seen, because never in the entire duration of our relationship has my daughter ever witnessed any violence at all between Mr. Day and myself. And as a matter of fact, Mr. Velasco, who I communicated with the entire duration of my relationship with Mr. Day, had told both of the children that if they ever felt in danger, felt unsafe, felt anything at all, that they needed to communicate with him. And there was no communication at all. So when I asked my daughter what she meant by that, she says, "Oh, you know when you and Justin play around?" And I said, "Sequoia, you can't say those things because it's misinterpreted." There is unfortunately a lot of questions in this child interview that can be interpreted in any way, shape, or form. Now, unfortunately, two different sides can take it any way that they want to take it. I live in my life every day. He lives in his life every day. Our children are exposed to this every day. I've had my father be present in my home every time that Mr. Day's been there, ever since he's expressed some concerns. There has been not one complaint, not one concern, one phone call, not any concerns to Mr. Velasco at all.
Well, I disagree because we're standing right here.
Listen, and I'll be very candid with you. It just, I'm like, you know what? I just don't recall because, again, my notes indicate that it was confirmed that your significant other has substantiated acts of domestic violence against you.
Against me, against myself, correct. Nothing ever against my children. And it wasn't actually ever proven.
I understand that. You, again, and I realize you represent yourself, but that is one of the factors that has to be considered when it comes to kids.
Absolutely.
In the home.
Judge Duckworth, Honorable Judge Duckworth, after hearing an entire trial that, lasted an entire day, felt Mr. Day fit and proper of an 18-month-old who cannot communicate, who cannot talk, who cannot anything, and granted him joint custody. He was allowed 3 days unsupervised.
Well, but those children. Dominic himself said he is a little scared of him. Kind of scared.
Well, hold on a second.
That's not what he said.
Hold on.
He
kind
said scared that he might. Well, anger management, if you were to read this entire child interview, there are specific things that are stated that are obvious that this was coached. Dominic's been to 2 different therapists, 2, and none of those words were ever used with either therapist without any coaching, ever. I can't imagine that a therapist, if a therapist was interviewing a child and they had said, "I'm afraid" or "I'm scared of this person," that they wouldn't deem that it's necessary to continue interviewing them and communicating with them. Both therapists, 2 separate times, never felt that they needed to talk to these children any further. Mr. Velasco had plenty of time to prepare his case to manipulate these children, and as a matter of fact, he allowed both of my children to read my pretrial memorandum. That's absolutely unnecessary, and I can't believe he did that.
So first of all, you're throwing me off with Duckworth. Are you getting judges mixed up? Because I don't see any Judge Duckworth in any of the history of this case.
Judge Duckworth was my judge in my custody case with Mr. Day. We immediately,
Who's Mr.
Judge Duckworth.
Mr. Day is the domestic offender.
Abuser?
Yes.
Okay.
We have a child together.
All right.
Mr. Day and myself.
Okay. And you're still residing together?
Yes.
No, we are not. He does not live with me. He lives in his own place. He has his own lease. He pays his own bills. Mr. Day has not lived with me since December of 2014.
Because
At
there was
all.
a TPO.
He does not live. That's actually not true. And I was under the advisement of counsel during this entire time once the custody case that Mr. Day initiated. I didn't initiate a custody case. Mr. Day initiated it, and I had no option other than to retain an attorney. I went through a very heated custody case under the advisement of my counsel. I did everything that she recommended that I do. When the verdict came down that there was joint custody after Judge Duckworth heard the entire case, front, back, heard testimonies, heard everything from both sides, he found Mr. Day fit and proper of an 18-month-old to have joint custody with. Now, Mr. Velasco then took it upon himself to ride the tail end of this, whom I've had communication with him the entire duration of my relationship. He, as a matter of fact, testified for me in my case in the fact that we co-parent extremely well, and that I had conversated with him multiple times during the duration of our relationship. I've never hid anything from him, and as a matter of fact, after our custody case, Mr. Day and everything got lifted, and he and I began communicating. I went through safe nest counseling from January until June, every 2 weeks, to deal with what was going on in my life. The moment he and I reconciled, I sat down and I spoke with Mr. Velasco, and I told Mr. Velasco, look, this is what's going on. I'm like, you need to just trust what I'm doing. Mr. Day, at that point in time, Mr. Day and I, for 6 months, checked into couples therapy. Every 2 weeks, we were going into couples therapy. Since then, December and January, I'm seeking my own therapist on my own to use as a safeguard. And as a matter of fact, my relationship with Mr. Day currently is by far the most healthy and positive relationship that there could possibly be. We've both learned different parameters. We don't argue. We don't fight. We handle our situation completely appropriate. And the problem that we're having in our relationship now is every time that the children go with Mr. Velasco, we have to come back and deal with all of this, just the negativism, and everything else that's going on. We've both gone through our therapist. They recommended that we continue doing family activities to desensitize them from the time that they're with their dad. We've been doing that. We've gone on multiple vacations. We do multiple family outings. We do everything that's possible to keep these kids actively involved. There's been not one phone call, not one text message, not one concern at all to Mr. Velasco in regards to anything going on in my home. It's sad and unfortunate that this is where it is today after we've been co-parenting for 10 years. The children are successful in school. The children are very active in extracurricular sports that I provide for them. I get to them every time that they need it. And I haven't gotten any help from him on the weekends when there's conflict. I haven't gotten anything. And I've never not given him any additional time that he's asked for. Anytime he wants to take the kids to California to see his family, I'm very cooperative. I don't have any abusive power over him, and we've worked for 10 years in this current situation. And it's unfortunate, which I believe this whole custody case is brought about because he doesn't want to pay child support. He doesn't want to pay child support, and he wants... I understand.
Domestic violence alone is a reason enough to bring a case back to court.
It absolutely is, Your Honor. But like I said, I've communicated with him the entire duration.
Let me just kind of cut to the chase, Ms. McKellar. And I don't know how your client is as far as finances. I mean, my preference is there is enough in that child interview of a concern that, I mean, I would like to keep it. It doesn't need to be to a PhD level, but at least some sort of outsource if he's going to have the financial means to be able to do that or not. Because at the end of the day, it is we can agree it's an L standard, correct?
Correct.
It's just going to go a far way if, in fact, I can get a third-party provider that look through whatever therapist notes and can do some investigating that I can't.
Correct, Your Honor. I agree with that. I don't know where my client is financially wise. I have not discussed an outsourced valuation for him. After reading the report, he still does have concerns, which is why he brought the motion to begin with. There's always a concern with a domestic violence victim who goes back to the offender, because this is what happens in domestic violence cases. And it only happens for a short amount of time until something gives, and then the kids are witnessing another event. I'm glad.
You just asked for asking sake, because I don't, and I know I'm not going to pull up Judge Duckworth's case, but if I were to, you have such a great relationship with him, if I were to run a criminal scope on him, what would his criminal history say?
Yesterday has nothing. There's the only thing he has under his.
He doesn't have the domestic violences?
No, there's no domestic violence. That's what I'm explaining to you.
There was a TPO, Your Honor. It's actually
there's nothing, not one incident, not one CPS
I would like
call,
a time to argue too. You have to go for a while.
Not one thing.
Go ahead.
There was actually a TPO, and it's extended, and it's case it's T-14160627T, and it talks about domestic violence events that occurred in the home when she was holding her baby. Him smashing her head into the wall or into the mirror with her mascara, him hitting her in the head. One of the kids, Dakota, witnessing this event, and my clients had a concern about it, and I think he should, and I don't blame him, because he has to send his 2 children over to that house wondering if Mr. Day's going to be there, wondering what's going to happen, wondering when the other shoe is going to fall. And I completely understand his concern. I think that he meets Ellis. If we need to have an evidentiary on it, most of my evidence is actually attached to my motion, and it's for the bulk of her case. And that's all I got. I mean, I've done this case before, and it comes down to the selection of mom selecting her children or her current lover. And, you're
yourself in a very precarious position if, in fact, you're saying you have no relationship with. He doesn't spend. You guys don't spend the night. You don't stay over.
No,
his...
we absolutely do. Your Honor, we have a
there
child
you go.
together.
That was different. No, you absolutely said we have a different residence. That was a kind of.
We do. Yes. So are
you together?
Yes, we're absolutely in a relationship. Absolutely. Yes, but we do not live together, Your Honor. So Mr. Day resides in his own home Sunday, Monday, and Tuesday nights. We do not stay together Sunday, Monday, and Tuesday nights at all. My father watches my older 2 children on Sunday nights. Mr. Day's not even around.
Why can't my client have Sunday nights?
Because, Your Honor, this then becomes another issue.
Because she doesn't want it to be joint like
that's
the kids want.
Absolutely not the case.
Interview.
So my 2 children.
On a temporary basis, why not just the Sunday?
Because, Your Honor, listen. So the status quo has been established that over the last 10 years, my children, I live less than a mile from the school.
Okay.
Both schools. He lives over 25 miles from the school.
Okay.
So we both work Sunday nights.
Okay.
He wants to pick up the children from a sitter at 2:45 a.m. to have them turn around and go back to school at 6 a.m. So there's been instances where they're tardy. That would be putting them at 3 days a week, Monday, Tuesday, and Wednesday morning at 25-mile drive to and from school. Now, Thursdays and Fridays, I have to be the parent that deals with them whining and crying every time that they're not getting enough sleep. I don't know what their bedtime has been established.
Would it be 2:45 in the morning?
Huh?
Would it be? He's saying it's 2:45 in the morning.
He picks them up. Yes. Go ahead. Yeah.
That's something we did during the summer. I picked him up from her house when I got out of work. But for a Sunday exchange, I can do Sunday morning. That's not a problem.
But then we run into the problem, too. For over 10 years, I've been the only person that's ever provided a sitter. In 10 years. On his custodial days, I've provided the sitter. He's refused to pay for the sitters I provide. He has never.
Is that a child support?
Absolutely, which is
$1,200 a month.
Right.
Which actually brings us to the other point with the new Nevada law on child support. It's household income. He's on his financial paperwork. He lied about his the household income on the child support because he's saying that his girlfriend, who he's lived with for 8 years,
Household. I don't know what you're talking about. First of all, there's no new law.
The NRS 070 states
I'm very familiar with child
it
support.
It states that now it's based on household income, and that cohabitants, which they've been living in a relationship together for 8 years, she contributes. It's her home. He failed to provide any.
It's a deviation factor.
There absolutely is, Your Honor.
She wants him to pay more
I'm
child
very
support.
sorry, but this is
Because
very.
of his
The
girlfriend.
fact that you're laughing at me.
I'm
is
not
very-
laughing at you.
Both of you are laughing at me, and I'm very sorry, but that's
Ma'am,
very
sit down.
unprofessional.
Sit down.
Your Honor,
All I ever said was
I'm
there
very
was no
sorry, but that's
change in the
very
law.
unprofessional. I'm representing myself, and I don't feel like I should be spoken to like that. I feel like you're mocking me
Why am I mocking you?
because you're making fun of me and you're laughing, both of you. She was in here for 15 minutes prior to even us coming in here. When I walked in here, the two of you were having some banter, whatever it is, which obviously, one, sets me on defensive, and two, now you're both laughing and playing around together. I'm very sorry, but that's just not professional at all.
I'll take it that I was laughing because I think it's kind of funny that
You were the
somebody.
one laughing in the video record will show. I can guarantee I was not
No,
laughing whatsoever,
Okay,
and
okay.
I was talking with her about a different case that has nothing to do with your case prior to this case.
Okay.
For the time being, Your Honor, my client only wants what the kids want, and that's what they put in the interview. He wants Sunday to Wednesday. That's, he originally moved for primary physical custody based upon his concerns for the danger of the children with the plaintiff still living or still being with Mr. Day. He's told her all along that he wants mostly what the kids want. The kids both have stated that they would like to be with Dad from Sunday to Wednesday morning. We could do Sunday morning to Wednesday after school. I understand and respect what the plaintiff is saying, that this has been the schedule for 10 years, but obviously this is before other prior facts and circumstances has come into this case that generally raise an eyebrow to the best interest of the children. My client originally did move for primary based upon a alleged threat or his concerns, but these kids, they want joint. They want to spend time equally with both parents. I don't see any reason why not. And that we can move. The only reason that the plaintiff doesn't want that to happen is actually because of money. As she has stated, she wants to start
I
considering.
don't have a financial disclosure form from you.
I already filed
Right.
one. It's in my paperwork.
I don't have one filed.
It's under my opposition.
It's not a.
Also, Your Honor, there are concerns as well as they want to talk about domestic violence. Mr. Day has no record at all. Mr. Velasco has a strangulation domestic violence charge against him that the DA picked up against his current girlfriend that I witnessed myself. It was happened at my home.
Over 5 years ago.
Regardless of the situation, it's still there's concerns. And his current girlfriend, who I've met only twice,
It was dismissed
and they've been.
everyone went to court. And Mr. Day smokes marijuana around the
He
kids,
absolutely
too,
does
if we're gonna
not.
bring it up,
He
because it said so in
absolutely
her paperwork.
does not. Absolutely does not. And Mr. Velasco's girlfriend's a current alcoholic, a severe alcoholic.
What is? I don't see a financial disclosure form.
I'm sorry. It was under my.
Yeah.
Oh, you have it correct. It was attached under my opposition.
For the record, too, the case number for the Q case is case number D-14-507147C. And there is 5 pages regarding about domestic violence against the plaintiff by Mr. Day. And then on page 6, it
they have
says
some
Mr. Day is a
reference.
habitual marijuana
All right.
smoker.
This was not hard for me. I am going to go ahead and outsource the matter for recommendation. The parties are going to split the cost of it. And that's in light of the fact that the domestic violence allegations from the plaintiff's significant other. And I believe if I did go back and play the videotape that the original portrayal that you gave is that you have a distant and separate relationship, but you have a good co-parenting relationship. And then that changed later on to no, we have a physical relationship.
No, that was with him. My co-parenting was with him in the first the
Yeah, I
interview.
misunderstood, but I thought you were talking
no,
about
it was
Mr. Day.
actually my relationship with him, and it's changed since then.
And so maybe this will alleviate your any bias because we'll outsource it and see what someone else has to say about it. We'll do Claudia Schwarz.
Okay.
Parties will split the costs. The issue
Your Honor,
is
I'm sorry, what happens if I can't pay?
it's
I
an
just
order
went
of the
through a very
court.
expensive custody battle, and I have no funds. That's why I'm representing myself. Is there help? Is there somewhere I can get help?
We don't have that in the state of Nevada.
Okay, so unfortunately, I'm letting you know now, I do not have funds to pay for any additional costs, or else I would have an attorney representing me right now.
So you're saying if I continue for 90 days and we're wasting
Absolutely
just
not.
everybody's...
No, I'm 100% about the children. If you feel that it's necessary that it gets outsourced,
I absolutely do.
Yes, I'm not disagreeing with that. I'm letting you know I cannot financially afford to pay. And I know that in the last case I was in that it was very expensive to outsource. Like I said, I paid $35,000 to an attorney. I'm broke. I have no money, no means of anything. And I believe that's also why he came in, because he knew I couldn't afford an attorney.
All I know is I have this situation in front of me.
Correct.
All right. I am sorry that you had your other situation, and Mr. Day, maybe Mr. Day, if he's the one who made you incur $35,000, might assist you in paying that back. Maybe, if you have such a great relationship with him. Or a family member. I don't know. But you are going to be responsible for half the cost of it. I will fill the referral out. And then we'll see what the... Because I'm still deferring. I have read the child interview. The child interview is enough for me to outsource. But I want an outsourced evaluation report before I determine whether I do believe that there would be adequate cause for me to modify the custody schedule. So, and I don't want this to feel like it's ending on any sort of sarcastic or whatever, but the temporary restraining order is still in effect. Is that correct?
No,
No,
Or it
it was
expired.
in effect for a year.
it absolutely was not.
When did it expire?
June 5th, the day we went to court, because Duckworth was just going across parameters before he had us go to trial.
Okay.
So June 5th was when it was
It's
released.
It's Exhibit A on my motion.
I just needed a date when it expired.
January 13th, 2015.
Oh, the temporary was January 15th, and then it was carried over to family court,
Right.
and then Duckworth continued it, well, really let it go on when he heard the trial on June 5th.
He dismissed it in June.
Yes,
Okay.
June 5th.
I didn't know. 90-day date, Madam Clerk?
That will be April 5th at 1:30.
Your Honor, are we going to change the schedule at all? Based on what the kids reported in the interview, to Sunday to Wednesday?
What day do you work on Sunday?
We both work Sunday from 6 to 2. The children stay in their own home, and I live less than a mile from both schools. He lives 25 minutes from the school and wants to pick them up at, 2:45 in the morning.
He already said that's not the case. He said in the morning when you're both at work.
Oh, Sunday morning.
You're
Well,
at
I would
work
like,
too.
I would like,
Who's watching the kids while you are at work?
oh, my father.
Right.
My father, who stays at my home, yes.
You know what, Ms. McKellar, let me do it this way. I will defer to what Ms. Schwartz. I'll let her make that decision. If she thinks that it's in the children's best interest to modify it temporarily, then I'll let her make that recommendation.
Okay.
Okay, but I want her to be able to. She's also going to be able to have access to, if she feels it necessary to look into Judge Duckworth's case, she's going to have the ability to do that. She will get a copy of the this child interview report, and she can make any temporary recommendations regarding the modification at any point.
Okay.
And
Can we please hear
if
the
for
matter of
some
child
reason your client needs to front the cost, I can assure you then just to get the thing moving, I'll simply order reimbursement and reduce it to judgment.
Okay.
Your Honor, can we also, on my counter motion, child support, he owes $7,500 in child support.
Since she doesn't have an FDF filed, I'm gonna ask for that to be deferred.
I didn't even know you
filed
had
my
an
schedule of
FDF.
arrears.
I'm sorry?
I filed my schedule of arrears, just like the last judge had asked me to. $7,500 that he owes in back child support.
I don't know if I got that.
I mailed it to you and I have proof of service.
My client tells me I don't remember seeing a
If you're
schedule.
if you've not received it,
Your
then
Honor, I
we'll
have proof of
just listen.
service.
We'll either we'll address it on the return date, or we'll do the same thing at the trial date. I mean, because you've never seen it.
I haven't seen it.
Go ahead and print out a copy for her, Madam Clerk.
I know some of it might. He said that he thought he saw something that went back to 2008, like way back in the boonies. I mean, obviously valid waiver argument.
It's all been garnished from his checks, everything from the court order date,
Well, if it's being garnished from his checks, then I don't understand what the plaintiff's argument is.
because there's been multiple checks that haven't covered the cost, and for the first 3 months he refused to pay child support. From the moment it was
If there's a
court-ordered,
case
he
with the
refused to
DA,
pay.
they're going to take out arrears. I don't.
They are,
understand.
and I would expect if there's an informal DA case that I get a DA
There's not.
printout.
No, I went through my attorney on that.
Okay. So the issue is simply going to be deferred now that they have that, and then they can go back and see if they can find any proof of payment. I don't know how far back it goes, though.
2008 from the court date. It was established.
I realize you do not have an attorney, but what she's indicating is there is such thing as called a waiver. If you don't do anything about it for 7 years, there's a chance you might end up with waiving it.
Just the last year.
You said, I thought you just said 7 years. I asked
It goes
you.
back from 2008. Yes, 2008 to the current date, but it's consecutively over time.
Okay, I haven't seen it, so we'll address it once, and you got to get proof of that you paid it. You understand that?
Yes.
And then file proofs. All right. 90 days?
April 5th at 1:30.
All right.
Thank you for the time, Your Honor.
All right, see you then.